On this episode of Law Weekly, we feature a conversation on the lessons from former President Donald Trump's indictment, the constitutional amendment and the restructuring agenda, and much more. We have the views of a professor of political science, legal practitioner, and certified alternative dispute resolution expert, Professor Babafemi Badejo. Also showing on the program, ahead of the deadline, some political parties have filed their various petitions at the election tribunals across the country. Plus a recap of the top trending stories from the courtrooms. Hello and welcome to the program. I'm Shola Shuyeli. My guest, Professor Babafemi Badejo, obtained his PhD in political science from the University of California, USA in 1982. Since then, he has gone on to become a legal practitioner, a lecturer, an author, and has also served in various posts, including as Deputy Special Representative of the Secretary General at the UN Peace Support Operations in several countries for about 24 years. I caught up with him in his home in Lagos, Nigeria, to get his views on recent developments in the political and legal space. I began our conversation with his views on the recent indictment and arraignment of former President Donald Trump, vis-a-vis the rule of law, and what lessons Nigeria can learn from it.
There's a lot we can learn, especially on the question of rule of law, because we like to borrow from the West, but we don't have the culture of follow-through on what we have borrowed. It's not usual here. If we can take care of corruption, because there is an inverse relationship between corruption and rule of law. You can never have rule of law where you have corruption reigning supreme. So if we can handle the problem of corruption, then it could be possible for a policeman to arrest a former president. Because when a president is in office, you can't arrest him. He has that immunity that we created into our constitution. But out of office, even if it's an ordinary traffic violation. But the problem is that here, we are not even talking about former president or former governor. Anybody can do you know who I am? And get away with it. A friend of mine said he was being arrested by a policeman for running the red light, and he parked, and the policeman came, and all he did was to say, hey, you want to arrest me or you want to have breakfast? And the policeman said, breakfast, sir. He said, I gave him breakfast and I went on. Just like that. So not to talk about a former president that you cannot go near to go and arrest and subject himself and bring himself forward. And you don't, because we must also put things within their perspective. Trump is not an easy person to deal with. All those having to surround his house in order to get the documents and whatever shouldn't be the case in a place like United States. He should be saying, come over, come and take everything you need, like Biden did. But that's not your Trump. So instead of waiting for them to deploy National Guards and FBI and all the rest of it, he surrendered, which are the things we don't have here. Or much of Africa that we could, if we are using their constitutional arrangement, then we need to start dealing with why are we not able to be transparent in getting people to be accountable.
Let's come back home to Nigeria and our recently concluded elections. What lessons, if any, do you think that we can learn from that?
There are so many things about our recent elections that it will be difficult to know where to start from in terms of the lessons, because a major portion of our past election is a recurrent decimal, the politicization of ethnicity. And that politicization of ethnicity is, in the large part, across the board. Across the board, those who can shout loudest are shouting about Lagos. But it's not a problem of Lagos. It's a national problem that Professor Ehosa Osage, Professor Kudiba Onoli, all of them have pointed to on the problem of politicization of ethnicity and as the recurring decimal in what's probably more unfortunate in this current, the immediate past election was the adding of religious identity into the process of election. Today, the Pentecostals are the most fundamentalists. People search for fundamentalists among Muslims. No, that's not where the problem is. The problem is with the Pentecostalists, because the issue, no, my own view, the issue that they made about Muslim ticket, what you call, the vice president is a spare tire, and in some cars you may never even use the spare tire for the life of the car, except in places like Nigeria where you pick nails all the time. And so what was the big deal that drove into church? Take back your country. So if we want to move forward, then we have to start emphasizing associational group interests as opposed to primordial group interests.
Let's talk about the courts. The Nigerian judiciary has come under some attacks in recent times from politicians and their supporters since the conclusion of the elections. Some people justify these attacks on recent controversial judgments given by the courts, especially the Supreme Court. What are your thoughts about that one? Do you think that the judiciary, do you think that these attacks are justified?
I, as a lawyer, cannot contest a Supreme Court judgment when it has been finally rendered. Of course, you can do analysis that also shows respect to that institution. So, in effect, we can take any of the judgment. I found some of them curious myself, that how could it end up be this way, but at the end of the day, the spirit is as the court pleases. And in that respect, we do not have an alternative arrangement. By the 1999 Constitution, the buck stops at the Supreme Court. So whatever panel they put together, we have to support and wait for that decision, as opposed to the effort of some of our people in trying to delegitimize the Supreme Court. All those unnecessary cacophony over the Chief Justice of Nigeria went to London. Should he no longer travel? But people conjure the fact that he was on wheelchair.
And he was in disguise?
Yeah, and then they called that a disguise. They didn't say there was a mask on his face. It was a selective choosing of words in order to delegitimize the Supreme Court. But we aren't going to get any answer out of all this. If you are not as lucky as some, and you are still able to stand on your feet very strongly, many people immediately, even once they see your age in some of those advanced countries, not here where you have to bribe to get a wheelchair, they will come at you. Do you need help? To drive you around the big airports and whatever. So what is wrong about the Chief Justice of Nigeria And they started linking the person that went to London 10 days before the president-elect went to France. And they were trying to make a link between Paris and London, just without, in all these passing off arrangements, all aimed at delegitimizing the judiciary before it even got there.
Prof, let's round off talking about the Nigerian Constitution and the amendments that we have seen. Do you think that it satisfies the restructuring agenda?
Well, I have fundamental problems with the 1999 Constitution, and I've been saying it and I've written about it. And I think that it is a wrong constitution for this country. What we need is a confederacy. A confederacy that in real terms we were before independence, in the self-government period, when every region had its own constitution, had its own government, and contributed towards keeping a center to take care of common interests. And even in some of those common interests, the West had its own procurement arrangements in London. And that was reduced a bit in the 1963 Constitution, but called Federalist Constitution, which we were using before military intervention, before Aguiyi Ironsi. And Nwabueze San, with big respect, changed it into a centralized entity. Since then, we have been having a militaristically centralized federation, because it all borrowed from that militaristic orientation of Obasanjo through to the Babangida Constitution, which people don't talk about. The 1989 Constitution was indeed proclaimed, but Abacha came in quickly and started making his own, which Abdulsalami rubber-stamped and gave to us. We need to go away from that. We need to have a sovereign national conference at which the different units, nationalities, that would have been countries on their own, because they are by far bigger than when you gather several European countries together. They don't have, some of them don't have the capacity, but they could have grown into it, rather than frustrating ourselves in continuing with this militaristically centralized federation that we are pretending to be running. Having said that, the things that were signed picked some issues that were worth it. For the railway, for instance, now being possible, for it shouldn't have been there. It shouldn't have been exclusive to the federal government. Even the arrangement of the air arrangement shouldn't be exclusive. It could at most be concurrent, in which, you know, when you go and create 68 exclusive issues and whatever, and you are now touching one by one as it pleases you, it's not a dissolution. Who cares what a local government is called? If the people want to call themselves Yewa, it shouldn't have to be a concern of the whole federation that we have to go through a process of amending the constitution, and now, okay, we have now put Yewa into the constitution. In fact, we should have abolished the federation having to determine the name of a local government. Several other things that we have been talking about are not touched. The question of state police, the question of the capacity of the states to provide security for themselves in a situation where the federal government has woefully failed. There is a little bit of a lull in kidnapping and all the rest of it, but there was the time when people had to have Amotekun, and even that Amotekun became frustrated almost immediately by the corruption and the federal government. You know, some governors chose to give up, and some, for their own reasons, were not keen in pushing the idea forward. So rather than this tinkering, let us have a real we the people's constitution.
Welcome back. Now, away from that interview to election matters, President Muhammadu Buhari, in his last Easter Day message as president, has asked Nigerians who are aggrieved by the outcome of the February 25th and March 18 elections to wait patiently and allow the legal system to run its course. And to the courts, the Supreme Court has dismissed the appeal filed by the candidate of the Social Democratic Party, Segun Oni, challenging the election of Biodun Oyebanji of the All Progressive Congress at the Ekiti State governorship election. After hearing his appeal, Justice Mohammed Datijo, who led a 5-man panel of justices, unanimously dismissed the appeal for lacking in merit and held that the fuller reasons for the decision will be given at a later date. A 3-member panel of justices of the Court of Appeal had earlier affirmed the June 18, 2022 governorship election in Ekiti State, which returned Oyebanji as the winner after securing victory in 15 of the 16 local government areas in the state. I
commend the Nigerian judiciary for being professional and for bringing ahead to this litigation.
Besides Ekiti, the satisfied candidates in the last general elections have also taken to the courts to file their various petitions. The governorship candidate of the People's Democratic Party in the March 18 governorship election in Ogun State, Ladi Adebutu, has formally filed a petition before the Election Petition Tribunal, seeking an order declaring him as the winner of the elections. The PDP candidate, joined by a member of his legal team, Chief Godi Uche SAN, and party chieftains, stormed the tribunal secretariat at the magistrate court premises in Abeokuta. Adebutu and the People's Democratic Party are the first and second petitioners, while the Independent National Electoral Commissioner, the governor of the state, Dapo Abiodun, and the All Progressive Congress Ogun State chapter were respectively marked as the first, second, and third respondents. The petition, which is based on 4 grounds, seeks, among other things, an order of the tribunal directing INEC to conduct a fresh election for the office of governor of Ogun State to the exclusion of the state governor and the APC.
Today, in continuation of our pursuit of our democratic rights, because we have had elections that we truly believe we have represented the people fairly, and the people have responded by voting fairly for us in an election we believe we won. However, somehow the system has failed. Therefore, because those people vested with running that system, some people in that system have failed. We have now sought to find redress within the ambit of the law.
Our grounds are many, and I think you should just have patience. When it is served on our opponents, they will tell you.
How many are on the team?
On the team, we have about 3 senior advocates in our team, and a host of so many other lawyers. And many of them are lawyers who, not just because they are being paid, but because of the fact that they believe that the mandate was stolen, and they also believe that this mandate can be retrieved.
How many grounds do you put forward, sir?
We have up to 4 grounds. So very solid ones. But it will be sweeter when our opponents tell you the grounds.
How many prayers?
Well, prayers are just that the right thing is done, and the man who won is given the mantle of office. That's our prayer.
And just before we go, let's check out some other legal stories we're tracking.
We begin with the report that the Federal Capital Territory High Court has issued an order restraining the National Chairman of the Labour Party, Mr. Julius Abure, the National Secretary, Farouk Ibrahim, and 2 others from parading themselves as national officers of the party. Others stopped from parading themselves as national officers are the National Organising Secretary, Mr. Clement Ojukwu, and the Treasurer. Justice Hamza Muazu issued the restraining order while ruling on an ex parte application argued by a senior advocate of Nigeria, James Onoja. In the application, Onoja told the court how the restrained national officers allegedly forged several documents of the FCT High Court to carry out unlawful substitutions in the last general elections. The senior counsel also tendered several documents to show that the chief registrar of the court wrote the Labour Party to discern several documents used for the alleged criminal activities by Abure and 3 others. Mr. Onoja adds that following their indictment by police investigation, the 4 people are to be arraigned in court, adding that warrants for their arrest have already been obtained. In a brief ruling, Justice Muazu held that the application and the supporting affidavits are a good case for the request to be granted. The judge subsequently ordered that the 4 people should immediately stop parading themselves as national officers of the Labour Party, pending the determination of the motion putting the respondents on notice. Meanwhile, the State High Court sitting in Benin has restrained the Labour Party and all its members from any suspension or purported suspension of its national officers till the determination of the motion on notice. No date has been fixed for the hearing of that suit. In Lagos, the Federal High Court sitting in Ikoyi has vacated the interim ex-parte order, stopping Mr. Roger Brown from parading himself as the Chief Executive Officer of Seplat Energy PLC. Justice Chukwujeku Aneke vacated the order while ruling on the applications filed by Seplat Energy PLC, Mr. Roger Brown, Mr. Basil Omiyi, and other persons affected by the ex-parte order. The court held that by virtue of Order 26 Rules 9 and 10 of the Federal High Court Civil Procedure Rules 2019, the interim orders of the court made on 8 March 2023 are discharged and vacated. On March 8, 2023, the court had restrained Mr. Brown from parading himself as the CEO of Seplat Energy, pending the determination of the suit instituted against him by some aggrieved stakeholders of the company over allegations of racism, favoring of expatriate workers, discrimination against Nigerians, and breach of good governance. However, the respondents in their various applications urged the court to set aside the ex parte orders, contending that the petitioners lacked the locus standi to file the suit. They also challenged the jurisdiction of the court to entertain the suit on the grounds that the complaints of the petitioners fall under the exclusive jurisdiction of the National Industrial Court. After vacating the order, Justice Aneke adjourned the matter till May the 16th for accelerated hearing. Staying in Lagos, a Chief Magistrates Court sitting in the Sabo area of Yaba has ordered the remand of a leader of the Igbo community, Izendigbo Frederick Wajagu, for allegedly threatening to bring the proscribed indigenous people of Biafra to the state. Chief Magistrate Peter Nwaka ordered that the defendants should be kept at the Ikoyi custodial facility for 30 days pending the legal advice of the State's Director of Public Prosecution, DPP. The Chief Magistrate made this order after Wajagu, aged 67, was docked before the court by the police on the 2-count charge of conspiracy and conduct likely to cause a breach of public peace. According to Nuruddin, this alleged offences contravene sections 168D and 411 of the Criminal Law of Lagos State 2015. And the coroner inquiring into the cause of death of a 12-year-old Christian school pupil, Whitney Omodisola Adeniran, has granted permission to the school to engage an independent forensic pathologist to review the autopsy conducted on the remains of the late Whitney. Magistrate Olabisi Fajana granted the permission while ruling on an application filed by Christian School seeking leave to access some items obtained from the corpse of the late Whitney. The school says this will enable it to consult with the independent forensic pathologist and to allow the consultant testify accurately on his findings before the court. Through its lawyer, Senior Advocate of Nigeria, Olukayode Eniton, the school told the coroner that the request was made because its representative pathologist, Olugbenga Oyewole, only attended the initial autopsy carried out by the government as an observer and did not carry out any tests or dealt with any samples. Counsel to the state government, Akin George, did not object to the application. George, however, applied orally that the court should order that the state pathologist must be in attendance during the consultation as an observer at the cost of the applicant. And we round off with a report that another Lagos court has dismissed a no-case submission filed by the suspended Assistant Superintendent of Police, ASP Drambi Vandi, who allegedly killed a Lagos-based lawyer, Omobolanle Rahim, on December 25, 2022. Justice Ibironke Harrison ordered the defendant to open his defense as a prima facie case has been made against him. The court also held that the prosecution, led by the Attorney General of Lagos, Senior Advocate of Nigeria Moyosore Onigbanjo, had established sufficient oral and documentary evidence linking the defendant to the crime, which required explanations from him. The court said that the evidence of the defendant, being the only other eyewitness who was yet to testify before it about the incident, will shed light on what happened that day. In his application on the no-case submission, Vandi asked the court to dismiss the suit and discharge him, claiming that he has no case to answer. In his argument, his defense counsel told the court to note, among other things, that none of the eyewitnesses saw the defendant shoot and that the ballistic report of the gun allegedly fired expressly stated that the bullet cannot be linked with any of the firearms recovered from the police officers at the scene. The case has been adjourned till May the 16th for the defendant to open his defense.
And that's our program this week. Thank you very much for watching. Be sure to catch the repeat on air or watch via our YouTube channel. I'm Shola Shieli. See you next week.